So following the Supreme Court's ruling granting Donald Trump's request for absolute presidential immunity, Trump wasted no time and filed in the Manhattan court, where he was convicted on 34 felony counts, a request to basically vacate the verdict based on the absolute immunity decision. I'll explain to you why he's making that request in just a moment. I think there's a lot of confusion out there from a lot of our viewers saying, how could he even make that request? The absolute presidential immunity ruling by the United States Supreme Court deals solely with official acts while somebody is in the office of the presidency. So what are we even talking about here? The hush money payments and the falsification of business records. Didn't all of that take place before Donald Trump was ever in office? How is this even an issue? I'll address that in a moment. Let me just show you first what the Manhattan District Attorney just responded moments ago. This was after Donald Trump's lawyers yesterday requested filed a motion and requested a hearing to basically set aside the verdict against him. And the district attorney's office responded and they said, look, we are in receipt of defendant Donald Trump's pre-motion letter dated July 1st, seeking leave to file a motion to set aside the verdict pursuant to the local New York rules based upon the Supreme Court's July 1, 2024 decision in Trump versus the United States. In that letter, defendant requested until July 10th, 2024 to submit a memorandum of law in support of such motion. While defendant's letter states that he does not object to an adjournment of the July 11, 2024 sentencing date, his request to file moving papers on July 10th is necessarily a request to adjourn sentencing hearing, currently scheduled for July 11, 2024, pending resolution of the motion. Although we believe defendant's arguments regarding immunity is without merit, we do not oppose his request for leave to file his putative request to adjourn sentencing, pending determination of his motion. We respectfully request a deadline of July 24th, 2024, 2 weeks after defendant's requested deadline to file and serve a response. I want to bring in Karen Friedman-Agnifilo, the former number 2 at the Manhattan District Attorney's Office, to really break down what that letter means from the District Attorney's Office, what you think is going to happen. Will this move sentencing from July 11th to some later date? I think it will. I want to get your take on it. And just very briefly before turning it back to you, Karen, I just want to address that question that I'm being asked over and over again. The charges have nothing to do with this presidency. So what are we even talking about? How can he claim immunity for acts that he did while he wasn't president? Yes, sure, the hush money payments, the interaction with Stormy Daniels, yes, all that took place before he was in office. But remember what the Supreme Court said in its absolute immunity ruling. They went beyond what Donald Trump was even asking. They found that a president gets absolute immunity for core presidential power. They get absolute immunity from official conduct while they were in office, and there should be a broad presumption that everything they do while in office gets absolute immunity. They don't get immunity for unofficial conduct or conduct that they engaged in before they were in office, which would seem to be the fact pattern here with the Manhattan District Attorney criminal case. However, and this is directly from the dissent right here from Justice Sotomayor, finally, the majority declares that evidence concerning acts for which the president is immune can play no role in any criminal prosecution against him. That holding, which will prevent the government from using a president's official acts to prove knowledge or intent in prosecuting private offenses, is nonsensical. In other words, if the conduct is viewed as official in nature, it is excluded from proceedings. So in the Manhattan District Attorney criminal trial, there was evidence of things Donald Trump did while he was in office. He did sign the checks while he was in office. He had an event at the White House while he was in office where David Pecker and Michael Cohen were at the White House. It was like a celebration event that they were holding for basically covering all of this up. We got testimony from Hope Hicks about Donald Trump's, pattern and practices and statements that he made to her while he was in the office. We heard from Donald Trump's assistant about him getting mail in the office, and how he got mail versus how he directed these payments not to go. So the issue, and Karen, correct me if I'm wrong, that I think that that Trump's lawyers are making, is all of that should not even been permitted to be introduced at trial as a way to show Donald Trump's intent. Not that that conduct predates Donald Trump's time in office, but that shouldn't even been allowed in evidence. So that's the issue. I've been blabbering. Karen, break it down for us.
Yeah, so there's something in New York criminal procedure law called a 330.30 motion, which is a post-verdict pre-sentence motion. It's that window of time when there's been a verdict, a jury's reached a verdict, but before the sentencing date, that you can make any post-trial motions that you want. It's very common to do so. The deadline for Donald Trump to file any 330.30 motion has long passed. I think it was June 13th that Judge Merchan said he had to file this motion. So really what they did was ask for permission to file this motion now that this new case has come out on presidential immunity that they're going to say impacts this case. So threshold number one will be, is this timely? Will Judge Merchan say, sure, I'll give you time, even though the deadline is passed for a 330 motion because you could not have filed this because this case did not come out. So that's the first thing that has to happen. He has to permit it. I think he will. The second thing that will then happen is the judge, assuming the judge does do that and assuming he does adjourn this a couple of weeks, Judge Merchan, is going to want to keep this on a tight timetable. So I think this will be adjourned at least 2 weeks, possibly more if he thinks he needs more time to have the defense file their motions, have the prosecution respond, and have him write his decision, because those are three things that have to happen in this time period. So he's a careful judge. He's going to want to make a record that comports with this Supreme Court immunity ruling. Now, the Supreme Court immunity ruling has remanded that case down to Judge Chutkan to develop a factual record. They chastised both Judge Chutkan and the DC Circuit for not developing a record on what was official acts and what was not official acts below. But that's a conversation for another day. Essentially, however, this particular case has had all of the fact finding it could possibly have. All the witnesses have testified. They've been cross-examined. So I think the judge is not going to hold a hearing. I think based on the record that has been developed, he is going to apply the tests that the Supreme Court has outlined in this sweeping immunity decision that you accurately characterized, Ben, as going far beyond what anyone asked for, what anyone thought would be the case. I mean, it's just shocking, this ruling. And so he's going to want to apply the law to the facts in this case. And he's going to want this chance to develop the record in order to preserve this case for appeal. So given this new huge ruling by the Supreme Court. So I think that's what's going to happen. I think when he applies this test, I don't think ultimately the case is going to be impacted at all. I think he will, what he will do is he's going to say, as you pointed out, that most of this is not official. In fact, don't take our word for it, take Donald Trump's word for it, right? Don't forget when Donald Trump wanted this case removed to federal court, okay? If you remember that whole proceeding that went to Judge Hellerstein in the Southern District of New York, he applied to have it, and he moved to have it removed under the federal officer theory. And he, in that litigation, he not only talked about how this was all how Michael Cohen was his private lawyer, et cetera. He also withdrew any claim of presidential immunity. And so I think the judge is going to find that he waived it with respect to this case. But even if you were to say, okay, it applies, there's so much out there that Donald Trump himself in this case has talked about this being personal, his personal lawyer, right? Michael Cohen was his personal lawyer. And this happened, it was a personal thing that this happened. I mean, the whole theory of the trial, right, was that this was all was that this was all personal. So I think there's enough of a record that he's going to rely on about that. Even so, if he were to apply the law to the facts, I think the only thing it could potentially apply to is what you said, is the evidence. Okay, there's going to be evidence like official tweets coming from the White House, from the White House Twitter account, et cetera. That will probably be found to have not been allowed to be introduced in this case. So I think but there's so much other evidence that was relied upon here. I think that was not anything that's going to be an issue. And so I think it's harmless error. But again, he has to make that record. So I think it'll be fine. I don't think anything's going to impact this, but I think it needs to be briefed. I think the record needs to be made. The judge needs to apply the law to the facts, and I think then everything's going to be will be fine ultimately. But the sentencing, in my opinion, will be delayed.
Yeah, and the district attorney's office here is being methodical. They recognize that if they were just to rush into sentencing on July 11th, then then there could actually be major errors that could be determined on appeal, and then they could risk actually the sentencing and everything being reversed and overturned. And so they're being methodical and saying, all right, we think, to Karen's point, that there is absolutely no merit to what Trump is saying here. So let's just go through the motions, quite literally. We could have a hearing on it. We can brief this issue, and this will move sentencing back slightly. But we don't want there to be any kind of issues on appeal. So this is the right kind of methodical move to do. That's why the district attorney's asking that. And finally, I agree with Karen, and my point is not that I think Trump's conduct is deemed an official act or a core presidential power. I absolutely don't. Where my concern was, and I gave this analysis the moment I read all 100 plus pages of that Supreme Court ruling, was the evidentiary issue where the Supreme Court went above and beyond even what Trump was asking them to do, and where they were saying that any evidence regarding conduct by Donald Trump while he was in office must be excluded. So then I thought back to the trial, and I was remembering that during the trial, there was lots of evidence about Hope Hicks, Trump's other assistant, who would talk about her relationship with Trump, events that were taking place in the White House. And as I was reading the Supreme Court ruling and then thinking, well, yeah, the conduct, that evidence was not the criminal acts at issue, but those acts helped show Donald Trump's mental state and his intent. Like that, remember the moment in the trial we reported when Hope Hicks started breaking down and crying because she was having a conversation with Donald Trump, and she realized that Trump was probably, lying to her and that he was covering, all of this stuff up. Communications with advisors could be determined under the Supreme Court's ruling to be an official conduct entitled to this presumption, and there could be a request to exclude that. And then if that gets excluded and this gets excluded, could you make the argument, and this is what Trump's lawyers are arguing, that if you have to exclude all of these things, there's either got to be a new trial or we have to just set aside the existing verdict. So that's where we're at. I tend to agree with Karen about where this nets out, but it's why the moment I got that Supreme Court ruling, I flagged that issue for everybody. And then sure enough, that's exactly where Trump was going with this. So anyway, that's where we're at. We'll keep you posted. Hit subscribe. Let's get to 3 million subscribers. Thanks to your support. Thanks for watching.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.